The Organization of African Unity declared on numerous occasions that Israel's use of force in 1967 amounted to an act of aggression. It should also be recalled that in the Wall opinion, the court determined that Article 51 of the Charter has no relevance where the alleged threats invoked by Israel to justify its conduct originate from within, not from outside the occupied territories. And even if one were to assume arguendo that Israel may invoke the right to self-defense as a circumstance precluding wrongfulness, which it cannot, it is patently clear that self-defense cannot justify Israel's practices. Self-defense is a narrowly construed exception to the prohibition on the use of force. Israel's practices that are designed to perpetuate its occupation can never satisfy the requirements of necessity and proportionality. Furthermore, as several states have already affirmed in their pleadings, the exercise of self-defense can never provide a valid basis for acquiring title to territory that is occupied as a result of the exercise of the right to self-defense. Moreover, given that many of the internationally wrongful acts attributable to Israel are violations of rules of jus cogens, it is our submission that self-defense cannot be invoked in this context. Article 26 of the ILC Articles on State Responsibility and Article 18 of the ILC Conclusions on Identification and Legal Consequences of Peremptory Norms of General International Law are clear. Quote, where the responsibility of a state for a breach of a peremptory norm is invoked, the state against which the breach is invoked cannot excuse itself from responsibility by raising any circumstance that might ordinarily preclude its wrongfulness. In short, the African Union submits that Israel cannot invoke self-defense as a circumstance precluding wrongfulness. Finally, Mr. President, distinguished members of the Court, I will turn to the question of the consequences arising from these internationally wrongful acts. The ILC Articles on State Responsibility affirm the customary principle that, quote, every internationally wrongful act entails the international responsibility of the responsible state. It is on this basis that in the Chagos opinion, after the court determined that the United Kingdom's continued administration of the Chagos archipelago constituted a wrongful act, it was held that the United Kingdom was under an obligation to bring an end to its administration of Chagos, quote, as rapidly as possible, thereby enabling Mauritius to complete the decolonization of its territory consistent with the right to self-determination. The same is required here. Israel must end its unlawful occupation of all the Palestinian territories as rapidly as possible in order to enable the Palestinian people to exercise their fundamental right of self-determination. This is the request that the majority of parties participating in these proceedings have made. The United Kingdom, however, is a notable outlier on this point. It argues that if the court were to address the status of the occupation and require Israel's withdrawal, that would undermine the Security Council's framework that is premised on reaching a two-state solution through a process of negotiations. The African Union does not agree. To condition the end of occupation on a negotiated settlement is to make the occupation permanent, given that the occupying power, Israel, refuses to negotiate on the basis of the two-state solution. And it has declared its will that it will never accept the establishment of a Palestinian state. Those states that purport to support the two-state solution ought to endorse calls for this court to unequivocally determine that Israel's occupation of the Palestinian territories is unlawful. This is especially necessary given the peremptory nature of the right to self-determination and the prohibition on the acquisition of territory by force. The modalities necessary to end the occupation as rapidly as possible could be decided under the supervision of the relevant organs of the United Nations. Israel's unlawful occupation of the Palestinian territories also gives rise to consequences for other states, including the customary legal obligations reflected in Article 41 of the Articles on State Responsibility, which are, 1, not to recognize any benefit accruing to Israel from the unlawful occupation, 2, not to lend aid or assistance to Israel that might further the occupation, and 3, to cooperate to end the unlawful occupation and to protect the right of self-determination of the Palestinian people. It is perplexing that the United States has challenged the customary status of Article 41. This long-established principle has been recognized by the court itself in the Wall Advisory Opinion and by the UN Security Council. It was even applied by the United States in 1932 in the context of the Japanese aggression against China in what was known as the Stimson Doctrine. Pursuant to this doctrine, the United States government declared that, quote, it cannot admit the legality of any situation de facto, nor does it intend to recognize any treaty or agreement that impairs the sovereignty, independence, or territorial integrity of China. The court should uphold this principle. In its written statement, the African Union offered various specific ways in which states may practically and meaningfully comply with these obligations of non-recognition, non-assistance, and cooperation. The African Union simply wishes to emphasize that occupation and self-determination cannot exist at the same place and the same time. If occupation is illegal, it must be ended to permit the recognition of self-determination. In closing, Mr. President, members of the court, the African Union reiterates its call to end Israel's occupation of the Palestinian territories. The injustice being wrought against the people of Gaza as we convene here in the Great Hall of Justice makes it imperative to end Israel's impunity and hold it accountable to the rule of law. The court of history may very well judge the credibility of international law on the basis of the outcome of these proceedings. The international community has let down the Palestinian people, but the African Union has faith that in this court, justice will prevail. The betrayal of the sacred trust that is the self-determination of the Palestinian people is an enduring injustice that pleads to be remedied. It is the only path towards ensuring a future of security, stability, peace, and prosperity for the peoples of a troubled region. Thank you for your attention.
I thank the delegation of the African Union for its presentation. The court will meet again this afternoon at 3 p.m. to hear Spain, Fiji, and the Maldives. The sitting is adjourned.